So this is company law class, and today we are doing membership of a company. Membership of a company. Membership of a company, that's what you're going to look at. You have the handout with you? I'm going to handout. Membership. So you're okay. So we are going to discuss the handout so that you go fast, as we have been doing. So I'm not going to write much. Who is a member of a company? Who is a member? What makes you a member of a company? A member is any person who is in the register of members. A member is any person who is in the register of members. So as long as you're in the register of members, whether dead or alive, even if it's a dead person who is still in the register of members, is still a member. As long as your name is in the register of members. Which means, what if you find yourself in the register of members of Safaricom Limited, yet you have never applied for membership? Are you a member of that company? You are, as long as your name is in the register of members. Are we together? That's what we call membership by estoppel. Membership by estoppel. We are going to discuss that. So as long as your name is in the register of members, then you are a member. Are we together? So meaning that even the person who has died and his name has not yet been removed in the register of members, he's still a member. So in determination of the membership of a company, courts will use the register. As long as you're in the register of members, you are a member. Who is a shareholder? Who is a share? This concept is very important to understand because we shall also be talking about shareholding without membership and membership without shareholding. We shall use those concepts. Who is a shareholder? And a shareholder is a person who holds shares in a company. A person who holds shares in a company. Someone who holds shares in a company. So if you hold shares in a company and you're not in the register of members, are you a shareholder? Let's say your name is not in the register of members, but you hold shares in a certain company. Are you a shareholder? Yes. As long as you hold shares in a company. What if you don't have shares in a company, but your name is in the register of members? Are you a member of that company? Are you a member of that company? Yes. I want you to think critically. We've said as long as your name is in the register of members, you are a member. Whether you have registered for that for membership or not. Sawa sawa? Yes. It's therefore possible for a person to be a member without being a shareholder, or a shareholder without being a member. Membership without shareholding. Membership without shareholding. Membership without shareholding. In case of a company, companies limited by guaranteed. Companies limited by guarantee. And number two, unlimited companies. These companies do not have shareholders. Is that true? With companies limited by guarantee, what are those companies? Which are those companies? We said NGOs, or charitable organizations. Is that okay? And what makes a company? No, that's not the answer. You are wrong. Describe three, we've told to write, describe three conditions for a company to be said that it is limited by guarantee. Yes? Yeah. It does not? It plows back. Plow back means returning those money that it makes to its objectives. Sawa sawa. So one is plowing back of its profits to its main objects. Or we can also say it's not a profit making. It's not for profit making. Sindio? Not for profit making. Not for profit making, and therefore plows back its profits to its objects. To its objects. That's one. Two. Yeah, it promotes science, religion, and other charitable activities. Three. Though that one we said is where a company wants to dispense away with the word limited. Number three. Number three. Its certificate of incorporation is stated that it is limited by guarantee. And another one. Does not pay dividends to members. Does not pay dividends to members. Kindly. What's the problem? Yeah. What is the problem? I think we did this so well last class. We did it so well in last class. Sindio, go back to your notes and see whether what the points you have stated are the right ones. You have those adults? Companies limited by guarantee. When is a company limited by guarantee? Plows back its profits to its objects. Two, does not pay dividends to its members. And three, the certificate of incorporation states that the company is limited by guarantee. Are those the answers? Those are the answers. So you need to be reciting them that way. So online doesn't have share capital. It doesn't have share capital. Yeah. Now, membership without shareholding, and we've said companies limited by guarantee. Those companies, they do not have a share capital, and therefore they cannot be able to issue. They cannot have shareholders. Two, unlimited companies. And three, in case of a deceased member who is still in the register of members. You say, as long as you're in the register of members, you are still a member, whether dead or alive. Are you together? A deceased member whose name has not been removed in the register of members. And number four, bankrupt member. What happens to a bankrupt when you are declared bankrupt? When you are declared bankrupt, your shares are transmitted. Your shares are transmitted to the trustee in bankruptcy. Can you note I've not used the word transferred? They are transmitted. Shares are transmitted. Shares are transmitted. Immediately you are declared bankrupt, your shares are transmitted to the trustee in bankruptcy. And therefore you cease to be a shareholder. But as long as your name is still in the register of members, he's still a member. Until his name is removed from the register of members, he's still a member. Tuko pamoja? Yes. Now, by the way, deceased member, his shares are also, this one is where their shares are transmitted to the trustee in bankruptcy. That's the bankrupt member. To the deceased member, upon death, the shares are transmitted. Shares are transmitted to the personal representative. To the personal, kwa hii lugha ya mama, lugha ya kienyeji, we say next of kin. But in law, we say personal representative. Are we together? So those are the explanations we'll give the examiner. You tell him or her that deceased member, upon death of a member, his shares are transmitted to the personal representative, and consequently, he's no longer a shareholder. Until his name is removed from the register of members, he is still a member. Bankrupt member, upon being declared bankrupt, his shares are transmitted to the trustee in bankruptcy. Until the name of a bankrupt member is removed from the register of members, he's still a member. Then, transfer of all shares. We can say it should be transferable. of all shares. Transferor of all shares. A person who transfers all his shares is no longer a shareholder. Is that true? But as long as his name is still in the register of members, he's still a member. Then subscriber to the MOA. Who are these? Did we talk about these people? Who are the subscribers to the MOA? We said they are who? Promoters who signed the association clause in the memorandum of association that they wish to come together to form XYZ Limited. Anyone who signs the memorandum of association during the formation of the company is a subscriber to the memorandum of association. And by subscribing to the memorandum of association, before you acquire the company's shares, you are a member but not a. So if you subscribe to the memorandum of association that X, me, X, Y, and Z will come together to form this company, we have subscribed to the memorandum of association. And by subscribing to the memorandum of association, you automatically become a member. But before you are, if you have not acquired the shares of that company, you are a member but not a shareholder. Yes.
What is the benefit of somebody subscribing to MOA and you don't have shares? The not shares now gives the chance. You are just a member. What kind of benefits do you enjoy?
For instance, what we are saying, there are no benefits because there are no benefits that will accrue if you are a member, if you are a subscriber to the memorandum of association, but not a shareholder. However, it's a legal requirement that before a company is formed, there must be subscribers to the MOA. So therefore, if you are promoting a company, you must agree to become a subscriber to the MOA for the company to be formed, for the company to fulfill, for the company to meet the legal requirements of registration. Sawa. Yeah, so that is a legal requirement that there must be subscribers to the memorandum of association before the company is incorporated. Sindio? Yes, yes.
What about the shareholders? Does it mean that all the shareholders are subscribed to them?
No, the subscribers to the memorandum of association are the promoters, the people who form the company. Now, within the, you remember the contents of the MOA? What are the contents of the MOA? We can list them down very fast. One. Yes? The name clause. 2. Registered office clause. 3. You've forgotten. Object clause. 4. Yes? Capital clause. 5. Association clause. Are you together? In the association clause, that is where we sign that si lazima hata kitu yote si lazima watu wasign, ni sisi tumeregister hii kampuni, si ni kweli? So in the association clause, that's why we sign that we have come together to form this company. By signing the association clause, we become subscribers to the memorandum of association, and that one we become members of the company. Pamoja. But before we acquire the shares of that company, we are members but not shareholders. And I'm becoming very concerned that we are not reading. You know, I just need to ask a few questions so that I know whether people are reading or not. You people are not reading. Yes. Yeah? I'm really concerned. Simple things like what makes a company, how do a company they dispense with the word limited, for instance, 6 marks. You know, see. Yeah? Promoting science, religion, commerce, 2, and charitable activities, 2. Yeah, should not be paying dividends to members, 3. Yes? 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 Does not have a share capital. Those were the conditions. Supplying back the profits. Let me see the online students, what they are saying. Repeat question. I've asked, what are the conditions for a company to dispense away with the word limited? What did we say? Public companies or private companies? Hata mkumbuki. The way I explained so passionately. Yeah? Yeah? The way I was so passionate. Yeah? The private companies. So the company that will plow back, so those are the conditions: plowing back the profits, promoting science, religion, and the other one was not paying the dividends to its members. Now, what about guarantee? What is the same? What about guarantee? What is the same condition for a company to be said to be limited by guarantee? One, yes, does not have a share capital. The certificate of incorporation is indicated that it is limited by guarantee. And then the third one, was that among the conditions? What I know is that does not have a share capital. And then it's the certificate of incorporation is indicate the member's liability is limited by guarantee. Sindio? Members' liability is limited by the amount they have guaranteed the company. Mukumbuke hizo points, because I even given you wrong answers and you're in agreement with me. You know, the moment I give you wrong answers and you're all in agreement, then I know things are not okay. Things are not okay. Things are not okay. If I give you wrong answers, you're supposed to challenge me. No, 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 no. Companies limited by guarantee. One, we said its certificate of incorporation is indicated it's limited by guarantee. The member's liability is to the extent of the amount they've guaranteed the company. And the third one is does not have a share capital. So are you getting? I need you to think, to be critical. We challenge one another. You tell me, no, mwalimu hapo, you are not taking us the right way. But sasa kila wakati mnakubaliana na mimi, I give it. That word, yeah? Conditions for a company, certificate of incorporation state, it is limited by guarantee. Yes. And even the online students, there's a problem. For them, they are not even responding fast. That one also tells me they are not aware. I'm experiencing issues with Zooms. It keeps on freezing. I hope it's not a common, maybe your internet. Is it a problem with others? Are we together so far? But now, kuna shida. Si tumejua kuna shida. Are we going to correct that problem? Yes, because I tell you, this is the easiest unit. Even as you go to work, unachukua tu handout. Na kama wewe una drive, pia unaweka ile video, recorded video hapo, unasikia mwalimu akiongea. Sawa? It's easy, it's that good. Si kama FR ni lazima ukae chini uanze kufanya mahesabu na calculator. This one you keep listening to it, you keep reviewing the handout. Even as you go for lunch, you look at it. Sawa? So what are we going to do to correct that problem? Yes? You read. We don't have time fast. We don't have time. We are now almost moving to July. The exams are in August. And by the end of July, you are supposed to have, as we read, as we come to class, you also read. We don't have other time to review those notes again. So that as we start the revision, you have the points in your fingertips. Now it is a matter of revision. Sawa, please. So exceptions to the rule of Turquand, so that I see. Hata inasema nini? Unaweza kubuka. Exceptions to the rule of Turquand. Yeah? One is okay, rule of Turquand. Who can state what it states? But I like it. That's negative. Online students, sasa mngekuwa mmesha type answers zote kuniambia mnajua. So Marina said negligence. Only Maureen who has given. I have how many online students? 58. None of them, only Maureen knows negligence. Ebu andikeni pese kwa haraka haraka. Mtu andike answer zake 4. Uandike answer zako 4 haraka. Online students. Albright has Albright ameibia ile ya Maureen, ile ya mwisho, kwa hivyo ni ya Maureen pia. Maureen is the only one who is giving me answer. Turquand case. Yes, you are correct. Yes? Irregularity. Yes. And that's why I have come to know. There's a time I used to teach company law and students used to pass. The moment I left, students started failing. Now I'm back. You should pass. Sawa? Because the problem with you people is that you don't read. Mnasomeshwa mzuri lakini you don't review the notes. Please, you have to pass. Sawa? Company law is not a unit at hii si kama FR. This is a unit and you can pass so easily as long as you read. Tuko pamoja? The Turquand case states that an outsider dealing with a company need not to know the internal procedures. That's what it states. That he can assume that everything has regularly been done so as to its internal procedures. Na tukasema pamoja. Si tulisema pamoja? That an outsider dealing, if I'm dealing with Safaricom Limited, I don't need to know its internal procedures. So if I sign a document, na baadaye niambiwe, hey, this document was supposed to be signed by the MD. And for you, you entered into the contract, it was signed by the CF. We are not going to pay you. What should I do? Nimempatia example. I have a contract of 30 million shillings. 30 million pesa. Nikapatiwa contract na Safaricom. Ni supply ABCD. Mimi nikaenda, I looked for those materials, I supplied them to Safaricom. Now I'm taking my invoice. The moment I'm taking my invoice, they tell me, attach the contract. And then yule msichana kwa hapo akasema, who signed this contract? It's the CFO. Now, you know, for such contracts, they should be signed by the MD, so we are not going to pay you. Na amekurudishia makaratasi hapo. So you know these officers, the way they behave. Akakutupia makaratasi hapo. What do you do? So what you sue. Now, after suing, what do you? So sue, and then definitely you sue, and then you say Safaricom failed to pay me. What do you do? In any time you sue, because we are teaching you to have legal knowledge, you must cite cases. So now the Safaricom will sue, and the Safaricom will become the defendant. Safaricom will defend and say that now what he did is that he signed a contract against our internal procedures. And the contract was supposed to be signed by our MD, but it was signed by our CFO, and consequently, that was violation of our internal procedures. So that is Safaricom defending itself. Now unyamaze. Yes? Now you will plead the case of Turquand, Royal British Bank versus Turquand, and make an argument that in that case law, it was ruled that an outsider dealing with a company need not to know its internal procedures. Are you getting? And now you will win the case. You will win the case. And now the judge will now make a ruling later, and he will say that they pleaded the case of Royal British Bank versus Turquand, and that case law states that an outsider dealing with a company need not to know its internal procedures. And then you are paid your that $1 million plus the legal, plus the costs of the suit, the legal suits, the legal costs. That's how you're supposed to reason out as a lawyer, sawa, as a person with a legal knowledge. Now, Safaricom will now say, after you make that pleading, what would Safaricom do? Sasa wanaachilia tu that $1 million iende hivyo. Watasema nini? Wataleta exceptions. Another time we had given the contract to him, we warned him that in future, any contract beyond 10 million, it must be signed by the managing director. So that means you had knowledge of the irregularity. So when you cannot plead the case of Turquand, it's the same as exceptions to the Royal British Bank, the case of Turquand. And one, knowledge of the irregularity. 2, negligence. 3, you are an insider, e.g. director. 4, the issue relates to a forged document file. Special resolution. It's a requirement that the transaction requires a special resolution. The articles requires the special resolution to be passed in regard to the transaction, and a special resolution has not been passed. Tuko pamoja? Are you together? Now, can you see, we are not training you company law for the sake of passing CASNEB exams, but even for the sake of your own, to deal with the matters here outside that require legal input. Are we okay? That require legal input. And in case a company goes into liquidation, when a company goes into liquidation, we are looking at membership without shareholding. In case a company goes into liquidation. And when a company goes into liquidation, you are no longer a shareholder. You are no longer a shareholder. You are no longer in shareholders. What you have, that is, you are members, but you are no longer shareholders. Are you together? Yes. So tomorrow, hata ni kesho tu, next class, nikiuliza membership without shareholding, you should remember all the 7 points. Membership without shareholding, you remember all the 7 points. So shareholding without membership. Shareholding without membership. And one is transferee. A transferee of all shares. A transferee of all shares. What does that mean? You have transferred all your shares from a company, so you don't have any shares. But your name is still in the register of, members. Are you together? And the bearer of share warrant. Bearer of share warrant. Bearer of share warrant. And what does that mean? A share warrant, if you have shares that are fully paid, if you have shares that are fully paid in a company, you can use those shares as a collateral. You can use those shares as a collateral. So in the event that you want to use the shares as a collateral, you are issued with a share warrant. Because you cannot use a share certificate as a security, because with the share certificate, they do not indicate whether some shares may be fully paid and other shares may be partially paid. But with the share warrant, the number of shares indicated in the share warrant are all fully paid. They are all fully paid. The moment you're issued with the share warrant, it means that you've indicated to the company that you intend to use your shares as a collateral or as a security for a loan. And what the company will do is that it will remove your name from the register of members. But you are still a shareholder. Your name is removed from the register of members, so you cannot exercise the rights of a member. For instance, you cannot vote. Yet, you are still a shareholder. Are you together? Until you clear with the company that has advanced you the security. That is when your name will be reinstated in the register of members. Sawa. Now, let's look at ways of becoming a member of a company. Ways of becoming a member of a company. Ways of becoming a member. Ways of becoming a member of a company. One is subscribing to the memorandum of association. Subscribing to memorandum of association. I think we said this, that the moment you subscribe to the memorandum of association, these are the promoters, they automatically become members of the company. Are you together? And number 2 is application. Number 2 is application and allotment of shares. Application and allotment of shares. Allotment means acceptance by the company to give you shares. It means the acceptance by the company to give you shares. When you apply to a company and the company allots you shares, then you automatically become entitled that your name be entered in the register of members. Are you together? Yes. 3, now the difference between allotment. Allotment, you get shares from the company itself. Whereas transfer, another existing member transfer the shares to you. Can we see the difference? So company cannot transfer shares. A company can do what? Allot. A company can allot. What about a bankrupt member? Because we shall also talk about membership. This person is becoming a member. The trustee in bankruptcy, it is transmit. Can you see the difference between the 3 ones? Allot, transfer, and transmit. 3 is transfer of shares. Who becomes a member? Who is becoming a member? The transferor. The transferor becomes a member once shares are transferred to him. Are you together? Yes. 3, 4, transmission on death of a member. Who becomes a member? Transmission on death of a member. Who becomes a member? Yes? Personal representative. This is the way you put your answers. You say that upon death of a member, the shares are transmitted to the personal representative, and the personal representative becomes a member upon his name being entered in the register of members. Are you together? Yes. Transmission on bankruptcy of a member. Transmission on bankruptcy of a member. Who becomes a member? Trustee in bankruptcy. So are you getting the argument? Then estoppel. Estoppel. I said that if you are aware that your name is in the register of members of a company and you do not take any action to have the name removed, yet you've never applied to be a member of that company, no shares have ever been transferred to you, but then your name is in the register of members of a company mistakenly. You are aware that your name is in the register of members of a company mistakenly, and you do not take any action to have your name removed, then you become a member by estoppel. Are you together? You become a member by estoppel. What happens is that happens during for instance, during liquidation. You know, during liquidation, the company has liabilities. So during liquidation, and then the company has liabilities and the members are required to meet those liabilities. And probably in that register, it had indicated you all have 50,000 shares that are not paid. Now the liquidators will come to you asking for, maybe each share is 2 shillings. So that's 100,000 shillings. Asking you for 100,000 shillings because the company XYZ is in arrears and you hold shares that are in that company worth 100,000 shillings. And then you start running to the court. So you run to the court, to say, no, I don't know them. I have never even become a member. Now the company will say that at one point we informed him that he's a member and he did not take any action. And the court will rule that you are a member by estoppel, and consequently you should meet the liabilities of the company. Are we getting? So anytime you realize that you are a member of a certain company, and you are not a member, you take action to have your name removed. It usually happens for the members who transfer their shares, because the company may fail to remove your name from the register of members, and even hold that you still hold those shares, yet you transferred your shares to another person. Yes.
That members who are to be the promoters. So are we looking at how we can increase the membership? Because I don't think there was a difference between the members and now the shareholders.
A shareholder is any person who holds shares in a company. A member is any person whose name is in the register of members.
So now after the company has been formed, the promoters have subscribed to the
memorandum of association. If you,
they were
they want to increase more members. They want to have more members into the company. Now, yeah, so one is subscribing to the memorandum, others will apply and be allotted shares in that company. Once you make an application to the company and shares are allotted to you, at one point you will feel that you want to transfer some of your shares. Some people will die and they have their shares transmitted to their personal representative. Some people will become bankrupt, and some people will have their shares transferred, but then mistakenly the company fails to remove their name from the register and send them an SMS to come for the general meeting. You know, that's an evidence that you are aware that your name is in the register of members, but you did not take any initiative to have your name removed. For instance, even an SMS that was inviting you for a meeting or an email, yet you transferred your shares from a company, but yet you did not take any action to have your name removed. Any liability, you'll also be part of that.
My question, another question is, once you apply to even some shares by the company, does it mean that automatically you become a member?
No. When you have make an application and be allotted shares of a company, then once shares are allotted to you, you automatically become a member. Your name is, you qualify that your name is entered in the register of members. Once you have shares in a company, then you qualify that your name is entered in the register of members automatically. Is that making sense? Once the shares, as long as you hold shares in a company, then you are a member of that company. That makes sense, eh? Yes. As long as you have shares in a company, you automatically qualify to have your name entered in the register of members. That making sense? Yes. Then you look at cessation of membership. Cessation of membership. How do you cease to become a member of a company? One is dead. And how do you explain that answer? You need to get answered that upon death of a member, his shares are transmitted to his personal representative. Then the company will proceed to remove the name of the dead member from the register. And therefore, upon his name being removed from the register of members, he ceases to become a member. Number two is bankruptcy. Upon a member being declared bankrupt, his shares are transmitted to the trustee in bankruptcy. The company will remove the name from the name of the bankrupt member from the register of members. Therefore, he ceases to become a member. Yes.
What now somebody is died, the shares are transferred to personal representative, the name is removed. So what happens if these shares don't have transferred?
Transmitted. The shares are transmitted to his personal representative, and now the personal representative is the one who will become a member and own those shares. Upon death of a member, who becomes the member? The shares are transmitted. We are using the word transmit. So you see, when we talk about membership, this person became a member, the personal representative, terminating the membership of the dead person. Upon the bankruptcy, the bankrupt membership was terminated. Who became the member? Trustee in bankruptcy. So it's like there is the swapping. Yeah, there is swapping. This one ceases to become a member, this becomes a member. This one ceases to become a member, this one becomes a member. So this membership of this person is ceased. Cessation, ceased. Then this one's become a member. 3 is liquidation or winding up. Once a company is liquidated or is wound up, once a company is liquidated or wound up, any membership is stopped. Any membership is stopped. Is that clear? Yeah. Upon the winding up becoming effective, once the company is declared wound up or liquidated, any membership is stopped or ceased. Then forfeiture of all shares. Forfeiture of all shares. And the word forfeiture means cancellation by the company for non-repayment. Cancellation by the company for non-repayment. The company had given you shares, 50,000 shares. You have not even paid any of them for the last 10 years. The company can cancel them. It cancels them. How hakuna. Is that clear? So the company cancels those shares, all of them. You must use the word all shares. If it forfeits a few, you are still a member. But if it forfeits all of them, then you cease to become a member. So cancellation, forfeitures, we said it's cancellation for non-repayment. Then transfer of all shares. Transfer of all shares. Transfer of all shares. We said here the transferor becomes a member. The transferee, if he transfers all his shares, the transferee, if he transfers all his shares, he ceases to become a member. Is that clear? Yes. Then valid surrender. Valid surrender of all shares. Now, there is an aspect of forfeiture is the company cancelling, but valid surrender is the person giving up his shares. Giving up his shares. He doesn't want those shares. The person, the forfeiture is initiated by the company itself, but valid surrender is by the member himself. Are you together? The member surrenders and decides that he doesn't want those shares. Then sale by company in exercise of lien. You did business law, you studied what is lien? Yes, to retain. Lien means where probably you have used your shares in that company to get a loan. For instance, let's say in Equity Bank. Equity Bank is a loan-giving company. It is a credit, it gives credit facilities to its members. Now, I use my shares in Equity Bank to get a loan in Equity Bank. So my shares are my security. Are you together? Now I'm not able to pay my loan. What will the Equity Bank do? It will sell the shares. It will sell those shares. Once Equity Bank sells my shares and it sells all my shares, that means in exercise of lien, it had retained my shares as a security for a loan, and then it sells those shares. Then I cease to become a member. That's clear, Senor? Yes. Yes.
Number 5 and 6.
Transfer is, there's nothing to do with credit facility, being advanced a credit in transfer of shares. For instance, in transfer of shares, I hold shares in one company, and then I transfer all of them to you. Without any, there is nothing to do with loans. But in this, number 6, is valid surrender of all shares is where I do not want to hold shares in this company and decide to write to them and tell them the company that the shares that I had subscribed and I have not paid for, kindly, I don't want them anymore. So I do not want those shares. But the transfer is where I transfer those shares from one to him, all those shares to him. See that? Yeah. And then rescission of contract. And if a shareholder receives a contract of purchase, transfer, or allotment of shares because of misrepresentation, within reasonable time, the person ceases to be a member of a company. So you realize that a certain transfer of shares, it was forged. And your name had been entered in the register of members. What do? So you cancel that contract of purchase of shares. It may be the transfer of shares. One person, the person who was transferring the shares forged the certificate, forged the document, certain documents. For instance, the transfer documents. Or you realize the allotment. No, this person, the company which was allotting you shares, there are certain documents that was forged. So you can decide to rescind that contract. Once you rescind that contract and the rescission is effective, you cease to become a member of a company. And then redemption of redeemable preference shares. What does it mean by what is redemption? Redemption means the company buys back its shares. The company buys back its shares. So the company which had allotted you shares buys back its all redemption. It should be redemption of all redeemable. Because if it redeems a few of part of them, then you are still a member. Redemption of all redeemable preference shares. If the company buys back its shares, or its shares that it had issued to you, and that is redeemable preference shares. Not all shares can be bought back. Indeed, it's illegal for a company to buy back its own shares. But now in that topic of share capital, tutakuwa tukisema it is illegal for a company to reduce its share capital. Exceptions. Kwa kila kitu tutasema it is illegal for something. Are you getting? When a company can buy back its own shares. So tuseme it's illegal for a company to reduce its share capital. Exceptions. Sawa. Kwa hivyo topic ya share capital itakuwa tu general rule na exceptions. Are you together? Yes. Are these points understood now? Yes. Then repudiation by infant. Repudiation by infant. In business law, we learned that any contract in sale of shares with an infant, he can decide to avoid it. The infant can decide to repudiate means the contract the infant decides to avoid it. And as long as he avoids it within reasonable time, before he attains the age of majority or after attaining the age of majority. So if the infant repudiates the contract of purchase of shares, note the difference between rescission and repudiation. In repudiation, there is no misrepresentation. There is no requirement of it to be misrepresented. As long the infant will go back and say, mimi, hii contract nilinunua shares kwenu, mi sitaki. Mtoto akona haki ya kusema, mimi hii contract nilinunua shares kwenu sitaki. Are you together? But in rescission, you must prove that there was misrepresentation. Is that difference understood? Has it come out well? In repudiation, there is no requirement that there be misrepresentation. So an infant who has bought shares, even from you, if you transfer shares to an infant, the infant can decide to say that I do not want these shares. And do not take him to any court of law. Because the law gives the infant a right to repudiate a contract of purchase of shares. Are we together? Yes. Then a disclaimer by trustee in bankruptcy. And what it means, when this trustee in bankruptcy, when the shares of a bankrupt member are transmitted to the trustee in bankruptcy, but the trustee in bankruptcy may decide to say that I do not want those shares. I do not want those shares. And that's what we call disclaimer. That's what is called disclaimer, where the trustee in bankruptcy decides that he does not want those shares. When he disclaims that he doesn't want those shares, then he ceases to become a member of that company. So ways of becoming a member and cessation of membership. Now we discuss capacity of the following to become a member. Capacity of the following to become a member. Discuss the capacity of the following. Examiner will ask you, discuss the capacity of membership for the following categories. Capacity of membership for the following categories. For instance, corporation. Can a corporation become a member of a company? We are going to brainstorm. Can a company become a member of another company? Can a company become a member of another company? Yeah?
No.
Unless a company can become a member of another company. Kama tuseme as holding, a holding is a member of the, a holding is a member of the subsidiary. Now I get another question. Describe three legal requirements for a company to be a subsidiary of another one. Describe the 3 requirements for a company to be a subsidiary of another one. 6 marks. Tulisoma. Iko kwa hii, tulisoma. Describe 3 requirements for a company to be a subsidiary of another one. If it holds more than 50% of the shares in the, if the holding, a company to be a subsidiary of another, if the holding holds, what was the question? To describe 3 conditions for a company to be a subsidiary. If the holding had more than 50% of the shares in the subsidiary. Are we together? Number 2, board of directors. Nikasema more than 50% of the board of directors come from the holding. One is shares, the second one is the board of directors. And number 3, if a subsidiary of another subsidiary makes the other one. Are you together? I give an example of if the company A is the holding and B is the subsidiary and C is the subsidiary of B, then C is also a subsidiary of A. Tuko pamoja? Yes. So a subsidiary of another subsidiary is also a subsidiary of the holding. That's how you write it down. That a subsidiary of another subsidiary is also a subsidiary of the holding company. Sawa? Yes. Now, a corporation, we said it can become a member. And you give an example. A holding company is a member of the subsidiary company. But a company cannot be a member of itself. A corporation cannot be a member of itself. You cannot become a member to yourself because the reason being a company cannot purchase its own shares. A company cannot purchase its own shares. Exceptions to that rule. One of the exceptions. Yes. No, you have to think critically. One of the exemptions to the rule that a company cannot purchase its own shares is redemption of redeemable preference shares. Are we together? Yes. So corporation, we have discussed it. Personal representative. Can he become a member of a company? How do you discuss it? On death of a member, the shares of the dead member are transmitted to the personal representative, and he becomes a member. 3, trustee in bankruptcy. He becomes a member because shares of a bankrupt person are transmitted to the trustee in bankruptcy. Is that clear? 5, bankrupt. Can he become a member? Yes, he can become a member if he subscribes, a bankrupt member, if he subscribes to the memorandum of association, shares are allotted to him or transferred to him until his name is removed from the register of members, he's still a member. Are you together? He only ceases to become a member when his name is removed from the register of members. So even when these shares are transmitted to the trustee in bankruptcy, he'll only cease to become a member when his name is removed from the register of members. Then foreigner. Can he become a member of a company? Yes, he can become a member of a company. As long as the company, as long as the country he comes from is not at war with Kenya. Is not at war with Kenya. Are you together? So if a country is at war with Kenya and you come from that country, then you cannot become a member of a company that is registered in Kenya. Are you together? You come from a country which is at war with Kenya, you cannot become a member to which of a company registered in Kenya. Because that country is an enemy of the state and you are also an enemy of the state. You're also an enemy of the state. That amounts to, nataka mwe mkifikiria legally, that amounts to lifting the veil of incorporation. At which point? Under the statute or under the court? Under the court. Lifting the veil of incorporation under the court, one of the, indeed the first answer, the first point is determination of character. A determination of character, the explanation we gave was that a person, if a country is at war with Kenya, and the company, the people behind that company come from that country which is at war with Kenya, then that company is also declared an enemy to Kenya. Sawa? Yes, an enemy to the state. Minor, can he become a member? Yes? Yes, you see this one, he became a member, sindio? An infant became a member because he can acquire shares of a company. However, he can decide to repudiate the contract. He can decide to repudiate the contract. Upon him repudiating the contract, he ceases to become a member. Are we together? Yes. 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 Yeah, oh, yeah. So if a minor has not attained the age of 18 years, then his parents will sign the contract on their behalf. But you should always be aware that you're entering into that contract with a minor who can repudiate that contract or purchase of shares. Are we together? Yes. Membership rights. Classification of membership rights. One, we have corporate membership rights. So these are rights. When it comes to corporate membership rights, these are rights that are conferred by law on members as a group. They are conferred to members as a group. And therefore, members only exercise them as a group. What happens is that there are those rights that you cannot exercise as an individual. They require that you pass either an ordinary resolution or a special resolution. For instance, what did we say about objecting, alteration of the object clause? You remember the alteration of the object, alteration of the memorandum of association. Anything to do with the memorandum of association, you want to change the name of the company. Can you change it as an individual? You must pass a special resolution. Who can give me the process of alteration of the memorandum of association, the first step? Andikeni tuone. Andikeni. Online students, kindly. Hey, we need to wake up. We need to wake up. Because Susan is telling me that the chairman calls for a special resolution. Is that making sense? The chairman calls for a special. Susan, you are wrong. Yeah. Susan, you are still wrong, but it's a good attempt. Abel, I want answers. Abel, I want answers. Albright, you have a point, but you are wrong. Board meeting passed special resolution to convene general meeting. I wish you did not mention the word special resolution. Nimeandika? Hapana, no reference to the notes. We had all the whole weekend. Since Monday. Is company law boring? Now, why is it that you are not reading? That is not boring, you find pleasure to read. There's like a problem. Can we agree that today we are going to sleep at 11 as we read company law? Yes, is that okay? And that is why sometimes I don't even find these classes. Ziko empty tu, hakuna mtu anasoma. Wait, please. Do you know, can I give you a secret? You need to start reading company law. If muki approach mtihani, you have time for FR. You have time for FR at the same. Unaelewa? Yeah, company law unachukua tu 20 minutes. Leo, imagine made through nature and classification and formation in 20 minutes. Yani juu unaona hii najua. Then the other 2 hours, 3 hours, you give them to FR. Lakini sasa ikifika kwa mtihani, hujui company law ni tisho, FR, unachanganyikiwa. The secret is this one. You start reading now for all of them. Then, towards the end, you'll have time for the problematic units. Power. So remain here. This place is closed at 10 p.m. Even today, we are going to close at 10 p.m. So you're supposed to remain here up to 10 p.m. If you are an online student, give yourself only this month and next month, September, to the break and October. Then towards the November, October, September, the whole of the September, it will be a break, as we wait for the results. Sacrifice. You kama hii hujui. Hey, online students wananiandikia the board convince a special general. Let me read from the Moses. I'm going to kindly repeat the question. Safina, I've asked the process of alteration of the memorandum of association, 8 marks. Moses Otieno, I just feel umeibia. Where. Well, umeandika the first point the way it should be. A board meeting to pass as the resolution to convene the general meeting. Is it correct? So, yeah, every online student to clap for Moses Otieno. He has saved you. Moses is correct. Maureen is saying a board meeting to pass resolution to convene a general meeting. Maureen is also correct. Susan is saying a special AGM is called by the chairman where 3/4 should pass the resolution. Susan has an idea. Maureen, convene the general meeting to pass a special resolution permitting them. Now that one, does it give you 8 marks? Moses, AGM is then convened to pass a dispensing. Do you know AGM? I didn't mention anything to do with the AGM. Because during the AGM, there is business of AGM. And one of business of AGM inakuanga gani? Declaration of dividend, appointment of directors. Yes? Yeah, appointment of auditors, appointment of directors to declare dividend and approve accounts. Nothing else. Sawa. Yes. So AGM should not come here. Altered MOA must be filed with the registrar within 14 days. So that's the last. So the process is a board meeting is held. A board meeting is held to resolve to. And what is the purpose of this board meeting? Yes? To pass a resolution to call for a meeting, not a GM, to call for a members meeting. Then a members meeting is held. And what is the purpose of this members meeting? To pass a special resolution. So naona sasa, where the confusion is coming in, kama sasa, sijui kama was Morino, anasema tu special resolution, huko tu aiweke huko ndani. As resolution ni kupass a special resolution. That is, a special resolution is a resolution passed by 3/4 of the members. Sawa. Number 3 step. Yes? Yeah, we notify the registrar within 14 days. Kwa notes ziko hivyo. Sasa mnaweza angalia kwa notes. And then kwa notes, it's always good to make reference to the notes. Those ones who are doing 3 units. Wakati wa MA na tax na audit, simkuje shule msome. Those ones doing 3 units. Mkuje shule wakati hamna unit. Umepata hizo notes? Umepata? Soma, read loudly. We need to move fast. Iko kwa MOA, leta nikuonyeshe. The last point under the MOA. So let me read for you the answers. Alteration of the MOA. 1, a board meeting to pass a resolution to convene a general meeting. Kindly, not annual general meeting. It's a general meeting. Convening of the general meeting to pass a special resolution. To permit the alteration of the MOA. The point 3 you have to just say, holders of not less than 15% of the issued share capital have 30 days to apply to the court to challenge the alteration. In law, any decision made by the majority, the minorities always have a right to challenge it in court. Sawa. Anything that is passed by the majority, the minority can challenge it in the court. Now, with this one, the law has stipulated a threshold. It has stipulated a threshold. The minority must be at least 15%, not any kind of minority, not 5%, 15%. The altered MOA is filed with the registrar within 14 days.
question regarding the 15%. Are we referring to one person getting,
even if one person holds at least 15%, even if I'm the only one and I hold shares in that company, then the share capital that I have in that company is at least 15%. I can go alone to the court. So, as long as the number of shares I hold in that company amounts to 15 or more percent. So you can imagine. Sasa mnaona mko zero bado. Hakuna point hata moja ungepata kwa hiyo 8 marks. The board convenes to pass a resolution to pass to resolve. Or you just put it this way, the board resolves to call for a general meeting. A general meeting is held that passes a special resolution. Holders of not less than 15% can challenge to the court to challenge the resolution. Then, if the court objects, if the court does not agree with the minority, so then we file the altered MOA with the registrar of companies, and it must happen within 14 days. Any alteration. Next time examiner atakuuliza, discuss the procedure of altering the name of a company. Name of a company. Object clause of the company. Anything to do with the MOA to change, to alter it. In company law, we use the word alteration in place of the word change. To alter MOA, to alter the name, to alter the capital clause, to alter the register anywhere. That's the procedure. Sawa. Wewe. We are not doing well. So what we are saying is that corporate membership rights are those rights that members exercise as a group. Those rights that you must pass a resolution. Right to apply to the court for cancellation of proposed variation of the rights attached to a particular class of shares. Alteration of any right attached to a given class of shares. Hiyo tutasoma kwa share capital. What this means is that if you are, for instance, let's say redeem preference shares, we shall say preference shares are entitled to a fixed rate of dividend. Sawa. Let's say they are entitled to a fixed rate of dividend. Kwa kampuni X, they are entitled to 20%. Kwa hivyo tukideclare dividend, tuna reserve 20% ya dividend yote yende kwa nani? Kwa preference. Sawa. Maybe tunataka sasa hapana, wanakula pesa mingi, not 20, they should not be taking 20%. From next year, they should be taking 10%. So that is a variation of class rights, Now, if you want to vary the class rights, then we need to pass a special resolution. Minority members who belong to that class can object that alteration in the court. Minority members can go to the court to object to that alteration. Hiyo imeeleweka? And that's a right. 3, right to apply to court order in case of operation of the minority. 4, right to apply to court for winding up of the company. Right to inspect without fee the register of debenture holders. Right to inspect without fee copies of the instrument creating charges. Right to require the directors to convene an extraordinary general meeting. Right to convene an extraordinary general meeting if the directors fail to do so. So what we are saying, these rights cannot be exercised by an individual member, but can be exercised by members as a group. They can only be exercised by members as a group. Tuko pamoja? Yes. Now, 2, individual membership rights. And individual membership rights, these are, we call them rights of a member. Rights of a member in general. Of an individual member. 1, right to dividend. Right to dividend. 2, right to attend AGM. Right to attend AGM. 3 is right to vote. Right to vote. And right to receive a return of capital. Right to receive a return of capital. Do you know what that means? Right to receive a right to receive a return of capital. Receive a return of capital in the event of winding up. In the event of winding up. Do you know what that means? In the event of winding up of a company, let's say this is company KC College Limited, and they had contributed 1 million shillings towards my share capital in this company is 1 million shillings that I have fully paid up, and the company is wound up. I'm supposed to be, my money of 1 million shillings is supposed to be returned to me. Sawa sawa. It's supposed to be returned to me. We shall talk about priorities. Now, the shareholders come as the last priority. Shareholders come as the last priority. We need to first of all pay taxes. We pay wages and salaries to the employees. Now, if there is a remainder, then it is returned to us. Are we together? In proportion of the contribution. Then the third one is corporate rights. The third one is corporate rights. Yes.
How is that different from the difference?
Dividend is paid annually, and that is the profits of the company. Once the company makes profits, it reserves certain profits to be paid as dividends to members. But capital is returned in the event of winding up. When you buy shares in a company, can you be, maybe I have bought some shares in Safaricom. Can I get back my share? Can I tell them that no? Can I get back my money for the shares I bought in Safaricom? No, you cannot. You can only transfer those shares to another person so that you get your money back. Sindio? But si atuende Safaricom waambie, sasa mimi sio hizo shares sitaki tena. Can that happen? Mnirudishe pesa yangu? No, you should transfer those shares to someone else for you to get back your money. Well, if there is nobody to transfer the shares to, then that money will remain there until in the event of winding up. Until in the event of winding up. Tumeelewana hapo? So that time of winding up, that is when you can have the return of capital in the event of winding up. But not to say that when you buy shares in a company, you can get back your money anytime you need it. You must get for someone to transfer those shares. Are you getting? That makes sense? Question? Yeah? SACCO shares. SACCO, as long as it's that SACCO has been incorporated, as long as it has been incorporated, you must get somebody to transfer those shares. You can't go to the company and tell them, no, I don't want I want my money back for the shares that I bought. They must get somebody to transfer those shares to. You only get back your capital in the event of winding up. And then corporate rights are those rights that are exercised by the company itself. These rights are exercised by the company itself. Do you know them? Does the company have rights? For instance, it can sue and be sued. It can own property. It can enter into contracts. So these are characteristics of a company. Characteristics of a. And number 4 is, corporate rights. We are done. Derivative action. Derivative action. I'll discuss this later. I'll discuss the case of derivative, but derivative action simply means when an individual member can sue on behalf of the company. When an individual member can sue on behalf of the company. Who should sue? First of all, who has the right to sue? The company itself. Does it have the capacity to sue and be sued? Yes. So it's the company which should sue. It's the company which should sue. Now, derivative action goes against the principle of force versus habeto. Because force versus habeto, for the case of force versus habeto, elaborates the matter of, elaborates the case of Solomon versus Solomon, that the proper plaintiff is the company itself. The proper plaintiff is the company itself. Because the company, plaintiff means the person who can sue. Sindio? Plaintiff means the person who sues, who can sue. Now, the company itself, because the company is a legal person. So meaning, hatujafika hapo but tutafika tu. The case of Force versus Haboto states what? The proper plaintiff is the company itself. Because the company has the capacity to sue and be. Are you together? Now, the company exercises its rights through the elected directors. Sindio? Kwa sababu si kampuni haina miguu ya kwenda kwa kotini ati isu. Sindio? Si lazima kuwe na watu wataenda huko, but suing on behalf of who? The company. Kwa ile kitu watasema Safaricom Limited. Sini directors wataenda wapeleke hiyo kesi. Sini kweli? Yes. So the company itself has the capacity to sue and be sued. And the proper plaintiff is the company itself. Now, how does the company make decisions? How does the company make decisions? Through the majority. The company makes its decisions through the is this new kweli? Sasa tunataka huyu akuwe director. Si ni majority watavote yeye kuwa director. Tunataka ku approve hizi accounts ziko sawa. Si ni majority wata approve kwa annual general meeting. So the company makes decisions through the majority. So meaning the case of Force versus Haboto is also called the majority rule. It's also called the majority because the company makes its decisions through the majority. Now, let's say in a case where I feel aggrieved. Kenye wamefanya, hawa majority ni baya. Kenye wamefanya ni majority, venye wamechomoa XYZ as the director, that one is not, that is illegal. That one is illegal. Our majority wame approve to borrow for 10 million shillings against the articles of association. Me as an individual, if I feel it's not right, as an individual of the company and as an individual member, I feel that whatever the majority have done is not right. What can I do? I can also sue on behalf of the company. I can also sue on behalf of the company to correct a wrong done against the to correct a wrong done against the company by the trustees, by the majority. Sawa? And that's what we call derivative action. That's what we call derivative action. When an individual member sues on behalf of the company to correct a wrong done against the company by the majority. To correct a wrong done against the company by the majority. Majority hawajafanya kitu poa. Do these things happen? Unajua ni lazima pia. Do they happen? Directors wanataka hapa hii contract wanataka kuiba pesa. Na ndio wanataka au majority directors hapa wanatupush hadi wakahoga watu, wamehoga kila mtu kwa members huko. So majority wakienda kama buge vyenye wanaedanga, finance bill inapita. Si ndio? Are we together? Nayo Omtata anaenda kotini anasu buge. That's a case of derivative, but that's we are not going into parliament. In case of the company, that's what we are calling derivative action. That's what we are calling derivative action. A company it's not a register. It's not a register. According to Rigathi Gachagua case 2022. Was it 2022 or 2023? Okay. I don't know. So that's it. So liability of members. So the liability of members definitely know it's either limited by shares or by guarantee. And when a company is unlimited, then liability of members is unlimited. Sindio? Then the register of members. Hiyo ni rahisi. What does it? Contents of the register of members. Na hizi maswali huulizwa. They are easy but they inaulizwa sana. Definitely it has name and address of members. Shares held by each member. amount paid or agreed to be paid by each member, date at which one became a member, and date at which one ceased to be a member. Sawa? Msisahau, nikiulizwa kesho, contents of the register of members, name of members, shares held by each member, date at which one became a member, date at which one ceased to become a member, and amount paid or agreed to be paid by the members. Now we look at location of the register of members. Location of the register of members. Where should it be located? At the registered office of the company. Should be prima facie, we say prima facie, or the general rule or the legal requirement is that the register should be located at the register office of the company. Sawa. However, it may be kept elsewhere if the company has agreed with another person to assist him, to assist it in making up the register, to assist it in making up the register. For instance, tunaweza sikizana na wakili, wewe utakuwa member akitoka muna update. Akiingia muna update. Unajua mambo ya register of members, si mnaona register of members is very important because it is the one that determines whether you are a member or not. So if mmesikizana na wakili, it can be kept elsewhere other than the registered office. So we can read, the law requires the register of members to be kept at the registered office of the company. It may be kept in another place provided it is made up at another office of the company or some other office of lawyers if the company arranges with some other person for making up the register. That other office, provided the office is not placed outside Kenya. That other place should not be outside Kenya. The registrar must be informed where the register is kept other than the registered office. Any other change, the registrar must be informed within 14 days. Kwa hiyo examiner atakuuliza discuss 4 rules in regard to the register, to the location of the register of members. Discuss 4 rules in regard to the location of the register of members. Then you say 1 is that the register of members should be kept at the registered office of the company. The second rule, the company may arrange with another, the register may be kept elsewhere as long as the company has arranged with another person for making up of the register. The third rule is that that other place should not be outside Kenya. And the rule number 4, the registrar must be informed of any other place the register is kept other than the registered office. Yes. Memorandum of association. Yes.
That point number 3, which was stating that some members who are
at least 15%
within that group. The last point was 13 days, within 14 days they are notified. So
that's a different. Yeah, it's just like the Supreme Court. Now I don't know the days that are required for the swearing in of the president. You must wait for the Supreme Court to make its decision before swearing in of the president. Is that true? We had to wait. For instance, I think the Supreme Court has 7 days to make a determination. Senior, we must wait for the court to conclude, to dismiss the matter. We must wait for the court to dismiss the petition by the minority. So the 14 days start counting upon the case being dismissed by the court. Sawa? Yeah. So the 30 days, within 30 days, indeed we must wait for 30 days to elapse before informing the registrar.
So somebody may come on the 30th day.
Yes. So we must wait after the alteration. For instance, after the special resolution, we must wait for 30 days to elapse. Sawa? So that we give allowance for the people who may wish to sue, to file a suit, unless the resolution is passed by everybody, 100%. So if it is passed by, no, if it is passed even by a threshold of 89%, unajua sasa kwa 89% hawajafikisha ile 15% legal requirement, si ndio? Yeah. So those are the debates that will go in court. That how mko amefikisha 15%. Are we together? Umechoka? So we go on. Index of members. Index of members. Now, for public companies with more than 50 people, for public companies with more than 50 members, it's a legal requirement for them to keep an index of members. It's a legal requirement to keep an index of members. Index of members is like the way we are issued with indexes in class 8 and form 1. That now you'll be asked, what's your index or your register? Your index is 001, 002. So for companies with more than 50 members, they should keep also index of members. It's like identification numbers. And what are the contents of the register of index of members? Index of members has the same content as the register of members. It has the same content as the register of members. So the index must be altered, the index must be altered within, for if there is any transaction in respect to, it must contain sufficient indication, and index should be kept where the register is kept. So rules in regard to the index of members are the same rules in regard to the register of members, including the location and the contents. Inspection of the register. Inspection of the register. What did we say about the inspection of the register? One, we have them. We talked about the members. They can inspect it free of charge. Sindio? Two, you also discuss about the debenture holders. What about the debenture holders? Debenture holders can also inspect it free of charge. And members of the public, they can only inspect it upon payment of a prescribed fee. So we can read it. Companies' register of members and debenture holders are public documents and open to public inspection. The law provides that register and index of members shall during business hours be open to inspection by any members without any charge, any other person on payment of fees prescribed by regulation. Any person may require a copy of the register or part thereof on payment of the prescribed fee. Meaning you can also ask for the copy of the register. You can ask for the copy of the register. In case a member requires a copy, it must be supplied within 14 days of receipt of such demand. If you want a copy, it should be supplied within 14 days. If a company officer refuses an inspection or fails to provide a copy, the company, a delivery officer of the company in default shall be liable to a fine not exceeding 75,000. Not exceeding 75,000. Now, if you go to the court can compel an immediate inspection of the register and direct that copies be required. That copies required shall be sent to the person requiring them. So 2 orders. Explain 2 orders that the High Court can make in regard to the inspection of the register of members, 4 marks. Explain 2 orders that the High Court can make in regard to the inspection of the register of members. 1, it can compel immediate inspection of the register of members. 2, it can direct that copies required be sent to the person requiring them. Tunaelewa? So those are 2 orders that the court can make. Rectification of the register. Can I tell you, one thing is that as we study company law, this is lifting of, hizi notes zimeliftiwa from the Company Act. Zimeliftiwa from the Company Act. Kwa hivyo, examiner akikuuliza, usiandike vitu zako, ati umeuliza rectification of the register, uanze kusema, this is correcting of the register. Whatever is here is what you're supposed to write in your answers. Sawa? Because this is what is in the Company Act. Ukiulizwa 2 orders that the High Court can make in regard to the inspection of the register, uanze kusema, it can jail or prosecute. Yeah? Unasema hizi tu, hizi zimeandikwa hapa. It can compel inspection of the register. It can also an immediate inspection of the register, and it can demand that a copy be released. Sawa? Yes. exactly the way they are here. So even when it comes to the rectification of the register, this is what the Company Act says, that the High Court, the law empowers the High Court to rectify the register of members in 2 cases. One, where the name of a person is without sufficient cause or reason entered or reason entered in or omitted from the company's register of members. You remember that person who was a member by estoppel? You remember him who was a member by estoppel? So what he's supposed to do? To apply to the High Court to have his name removed from the register. Or you find that your name is not in the register. What do? First of all, you make an application to the company. If it refuses, then you make an application to who? To the High Court. Sawa. So meaning one of the reasons why the High Court may give an order for rectification. For rectification, if a name of a member is not entered in the register of members, or is omitted from the register of member, or a name is entered in the register of members and is not supposed to be in the register of members. And number 2, default is where default is made or unnecessary delay takes place in entering the register. So one is a name of a member is omitted from the register, or a name is in the register, whereas it's not supposed to be in the register. And 2, unnecessary delay. Unnecessary delay. Default or unnecessary delay. Who can make application to the court? 1, the aggrieved person. The aggrieved person. The aggrieved person, for instance, my name is in the register of members, yet I'm not supposed to be a member. I'm an aggrieved person, but I'm not a member. Sawa. Second, a member. Even if you are not the aggrieved person, any member can make an application to the High Court for the rectification of the register. And 3, the company. The company. So the court may make the following orders. The court may make the following orders in regards to the rectification of the register. Unaelewa? Kulikuwa na orders in regard to the inspection of the register. Sindio? Orders in regard to the inspection of the register. Na hizi ni orders in regard to the rectification of the register. 1, refuse the application. Refuse the application. Order rectification of the register, and the payment by the company at any damage sustained by the aggrieved person. Are we together? Yes. So no notice of trust or register you achane nayo, tuende kwa the majority rule. Majority rule. Tumesema is the same as the case of Force versus Haboto. The majority rule is the same as the rule of force versus and what does it state? Kesho nikiuliza mnaniangalia tu. That the proper plaintiff is the company itself. Yes, the proper plaintiff is the company itself. It's also called as the Force versus Haboto, also the majority rule. So in other words, companies have the right to make their own decisions, and they make their decisions through the majority. They make the decisions through the majority. Principles of force versus Haboto. Principles of force versus Haboto. 1 is the proper plaintiff principle. 1 is proper plaintiff principle. And what does it state? That the proper plaintiff is the company itself. Number 2, internal management principle. Internal management principle. And what does it state? That the courts do not want to interfere with the internal management of the company. Courts do not avoid. Courts hazitakagi because kuna sheria. Si kuna sheria ya Company Act. Na sheria ya Company Act imesema that certain decisions can be made by members through ordinary resolutions like declaration of dividend, election of directors. Sasa tuki-elect directors, sindio? Simnaonanga kuna vita between parliament and courts, sindio? Courts feel that, parliament feel that courts should leave us to make our own decisions. The same thing, courts do not want to interfere with the internal affairs of the company. They do not want to interfere with the internal affairs of the company. And the third one is irregularity principle. Irregularity principle. A member of a company cannot generally sue to rectify an irregularity or informality which the company can by its members internally correct. In other words, irregularity principle means that the company can correct that irregularity. So in other words, when you go to court suing, court itakuuliza, did you write the letter to the company itself to correct that irregularity? We useme no. Utaambiwa, first of all, do a letter to them. Sawa? Utaambiwa, first of all, do a letter to them. Tuko pamoja? So the three principles under the case of Force versus Haboto are the proper plaintiff principle, the internal management principle, and the irregularity principle. That the irregularity principle states that the company can correct irregularity done against it. Sawa? Yes. Are we together? And therefore, we now finalize with the derivative action. Kesho nikiuliza Force versus Haboto what it states and the principles mnijibu. Sawa? Yes. Now, derivative action, nikasema, it's instituted by a shareholder in his name on behalf of the company to remedy a wrong done to the company. To remedy a wrong done against the company. Now, this person, when a wrong was done against the company, maybe that wrong was done by the majority shareholders. And I raised complaint in that meeting. For instance, I raised a complaint against that meeting. Why are we undertaking a traverse act? We should not. And therefore I told them, I'm going to sue on behalf of the company that you correct this wrong. Sindio? See, the company has refused to correct that irregularity. Now I will sue on behalf of the company. As a shareholder, I'll sue on behalf of the company. And that's what we call derivative action. That is when a shareholder sues on behalf of the company to correct a wrong done against the company. Are you together? Yes. Characteristics or conditions of derivative action. 1, fraud on minority. Some of the things that may make me to sue on behalf of the company. 1, there must be fraud. There must be an element on fraud of minority. 2, control. And control means that those ones who are doing the wrong are in control of the company. Those ones who are doing the wrong are in control of the company. For instance, they may be directors or the majority shareholders. 3, representative. In other words, it is not me suing. Is it me suing? Me, I'm just a representative on behalf of the company. I'm suing on behalf of the company. I'm suing on behalf of the company. That the plaintiff sues on behalf of the company. So that case he's taking, that derivative action matter is not the one who is suing. He's suing on behalf of who? So meaning we can assume it's the company suing. It's the company suing. And then nominal dependent. And the one who will depend, nominal dependent, in the case, the one who will benefit from the court ruling is who? Is it the company or me? It's the company. It is the company. So conditions for derivative action. 1, fungeni macho. 1, fraud on minority. 2, 3, 4, nominal dependent. And now we finalize with exceptions to the rule of force versus Haboto. Exceptions to the rule of force versus Haboto. Sasa, exceptions to, what is the case of the rule versus Haboto? Case of rule of force versus Haboto inasema nini? The proper plaintiff is the company itself. When is the plaintiff not the company? When the plaintiff is not the company. Meaning, the exceptions to the rule of force versus Haboto are the same as exceptions to, are the same as reasons for derivative action. When, in other words, when an individual shareholder can go to court and sue on behalf of the company. Does that make sense? Now, the company is not the plaintiff, it's the individual shareholder being the plaintiff on behalf of who? The company. Sindio? One is a traverse or illegal act. The company wants to undertake a traverse or illegal act. Is that making sense? Because if the company wants to undertake a traverse act, si wame approved through the majority shareholder, wataenda kujisuu kweli? Wataenda kujisuu? Si ni mimi niende nikasuu hawa wanataka kufanya nini? Something that is illegal. Two, special or qualified majorities. Special or qualified majority. For instance, I give you an example. To alter the memorandum of association, it requires special resolution or ordinary resolution. Special resolution. Hebu tuseme kuwa haikufika threshold ya special resolution, haikufika special majority sio wali approved. Special majority means that 3/4 of the members approved the alteration. Haikufika that threshold. Na tena nataka na hata kwa haikufika, they want to proceed with altering the memorandum of association. An individual shareholder can sue on behalf of the company. An individual shareholder can sue on behalf of the company. 3, infringement or violation of membership rights. Infringement or violation of membership rights. Wamekudeny the right to vote, the right to AGM. Wamekudeny the right to attend AGM. You can, wamedeny hata mtu mwingine. An individual shareholder can sue on behalf of the company. And 4, fraud on minority, misfraud on minority. And 5, oppression of the minority. So that one brings us to the end of the topic. Yes, yes. That brings us to the end of the topic, membership. Hizo zingine zimeandikwa hapo, achaneni nazo. Sawa? Okay? Yes. So tomorrow, you prepare yourself for nature and classification. The second topic was